All right, good morning. Hopefully everybody is doing well. Let me let some more people in. We're about 5 after. So let's turn our cameras on and let's get started. Professional standards. Today we were supposed to be reviewing professional standards. So far we have covered, hold on, let me just let somebody else in. So far, we've covered Osborne. Today, we are going to cover Russo. We are not going to have a chance to cover the last case because I've had enough of you who have done the connective quizzing. Thank you so much. But many of you who have done the connective quizzing have questions about the connective quizzing. So let's get through Russo. Everybody ready? Let's go. I'm interested. After having read Russo, what are your thoughts? You're about to be a lawyer. You are about to be a member of this profession. And once you become a member of this profession, you're going to be held to some standards, professional standards. There's going to be some expectations that you're going to do and behave and conduct as the other members of this profession would expect you to. So with that being said, would you prefer, Ms. Brown, you have a question?
No, I don't have a question. I was just going to answer your question.
Oh, okay. All right. So with that being said, let me, hold on, got somebody else coming in. Come on in, welcome. Let me admit you, perfect. So with that being said, right, you don't really have a lot to say about the standards, especially when you're brand new, right? When you're brand new, you come in, these are the expectations. This is how you govern yourself accordingly. With that being said, would you prefer to be held to a professional standard based upon local practices? Would you prefer to be held to a professional standard based upon statewide practices? Would you prefer to be held to a standard based upon national practices? Ms. Brown, your thoughts?
I think that there needs to be a mixture of them in a sense that I think that if we hold attorneys only to a local practice, that's like almost saying, okay, since you didn't go to a T14, we're not going to hold you to a T14 standard. We're going to hold you to the standard of the place that you attended. And I think that at every school, you're learning the same laws. So I don't think that should apply. I think that when it comes to the local standard, it's, for example, you have common law and you have civil law. With common law, the laws will vary as opposed to a civil law state. Their laws are very tailored to their state. So you don't want to compare a state like Louisiana attorneys to what would a Texas attorney would do or what a Florida attorney would do. So I think that there needs to be a mixture of them all.
Okay, thank you for that. Ms. Richard, what are your thoughts?
I think from a client's perspective, I would want my attorney to have to be held to the same standard as attorneys everywhere. Like in this case, you have the attorney didn't tell them about the non-compete agreement. I would like to know that as a client, but from an attorney's perspective, like Ms. Brown said, we are educated at different places. Like someone from my small town in New Roads, they might not have the same knowledge or might not need the same knowledge as somebody in a big city like New York. So I could see how the community where you practice can make a difference, but from a client's perspective, I would want my attorneys to be held to kind of the same standard.
The same standard as attorneys in the locale, the same standard as attorneys in the state, or the same standard as attorneys in the nation?
I would say state, because I feel like nationally it's way too broad. Okay. Like laws in Louisiana civilly are totally different from common law states. So that wouldn't translate.
Okay, all right. Last one, Ms. Falato, what do you think? Would you want to be held to a standard of your peers, right? That reasonable attorney standard, right? Would you want that to be a local standard? Maybe the parish that you practice in, or the city, or the county that you practice in? Would you want that to be a state standard since you're licensed in that state? Or would you want that to be a national standard, especially now that more states are going to the uniform bar exam? What do you think would be the most prudent?
I definitely don't think it should be the local, just because I think it should be state. Like, for I think I just agree with like how it is now, where everybody kind of has their own state things, and then things that maybe are of national concern and national matters. That's why we have the Supreme Court system, and that's why they go there instead of being state addressed, because I feel like if it's more national, I feel like that takes away from like individual state democracy, if that makes sense.
Right, right. We've got the 10th Amendment for a reason, right? So, Ms. Falato, would you then go local? Would you go state, or would you go national? What's the standard?
I would go state.
State. All right. Ms. Gandy? Can't hear you. Ms. Gandy, we can't hear you.
Sorry, I was talking. Sorry.
That's okay.
So I was thinking I would go state, and the reason being is because when we take like the bar, it's different jurisdictions, right? So we take the bar, you know, Louisiana got different laws and things of that nature. Texas got different ones. Washington as well. So I would say definitely state. Local is too, as it says, local. It's too confined, I guess I want to say, and then national is too broad.
Okay.
So.
All right, well then, fantastic. I appreciate your comments on that. Let's go ahead and move on, and let's see what Russo tells us. Let's see what Russo tells us when it regards, as it relates to the standard. Let me start here, which is different from where we've started for the last class. Are there any specific questions about Russo? You've read it, you've briefed it, I have it, I'll grade it, but having read it already, having briefed it already, having probably reviewed it for class today, do you have any questions about Russo? Facts, procedural history, issues, rule of law, questions? Ms. Patterson, Hill, Mr. Lane, questions? Anything that you're like, nope, that didn't make sense to me, or no, I wasn't sure what they were trying to do, or I'm not sure what they said? Questions. Let's start from questions. I'm not getting anything from Patterson, Hill, or Lane, so let me just roll over. Let's see.
I'm sorry, I do have a question. My Wi-Fi was going out. I didn't hear you.
Okay, all right.
So, it's about, it's about
Okay.
the locality rule in general. So
Okay.
like, I understand that the locality rule, well, as they put it, it was about like, them going, not based off of a geographical standard. Or
Okay.
is it the other way around? Like, are they saying that it's not going off a geographical standard, or it is going off a geographical dimension? Like the way
It's
they
going off of a geographical standard.
Okay, because the way they said it made it seem like it was more so a community custom thing.
Which is a geographical standard.
Yeah, okay. I was kind of confused about it. It was the way they were putting it, it just didn't make any sense to me. But that's my own question.
Right. And so really, I think what they were trying to do interchangeably, they being the reviewing court, what I believe the reviewing court was trying to do by using this interchangeable language was to try to express the community by which you will be judged. The community of professions by which you will be judged is going to be based on a geographical limit. Now, should that geographical limit be the local community? Should that geographical limit be a statewide community? And if you read outside of the book, Lexis, Westlaw, you would have found that there was a dissent in this case. And the dissent in this case said that the community, the geographical limit of the community should be universal. Right. And that's the only thing that you probably would have pulled if you read outside of this case, because the Lexis notes follow. This was a shorter case. And so the opinion in this case is almost fully captured in what you have in the book. But with that being said, anybody else have questions? Anybody else have questions going again? Nope. No questions? All right. Somebody's talking. Who's talking? Ms. Kilgore?
Yeah, I had a moment. First of all, that's what Patterson was saying. So you're saying like the community that will serve is the state.
Okay, you're real muffled.
Can you hear me now?
There you go. That's so much
Okay,
better.
sorry. Yeah, I was to build off what Patterson was saying. So you're summarizing it like community by which you serve is community by which you'll be judged. But the argument was to make it universal, so if not to make it so local.
So the issue is this is community, right? We already know from Osborne that if there is a professional standard to be questioned, we're going to have to look at the profession and not the lay community, right? Osborne already told us that. If there's professionals involved, you can't look at the lay community. You can't use a reasonable person standard. You got to use a standard based upon the practices of the profession. Osborne already told us that. Russo is adding to that. Well, where's the community?
Oh, yeah.
What's the community of professionals? Is the community of professionals local professionals? Is the community of professionals statewide professionals? Is the community of professionals all attorneys in the United States? Right, so that's what we're trying to determine, because what do we have in Russo? We've got experts. We don't have any lay people. We don't have anybody trying to introduce a reasonable person standard. We've got professionals. We've got professionals that say, this is how we do it locally. And we've got professionals who say, this is how we do it statewide. So what are we going to do? Are we going to do it what local lawyers do as a custom and practice in their locale? Or are we going to do what lawyers do statewide as a practice? That's what Osborne is trying to define for us. Ms. Kilgore, did I answer your question? Okay.
Yes, ma'am.
Perfect, thank you. All right, well, if there's no more questions, let's get to quiz. Since everybody understands Russo, we don't really need to talk about it anymore. Let's go to the connected quiz. I have reproduced in this PowerPoint all 10 questions. Some of you have taken it. I appreciate those of you who have taken it. Some of you have not taken it. I'm not grading it either way. I appreciate that the people who took it are trying to test their knowledge outside of my framework, right? They're trying to take this knowledge and apply it in a greater realm to see if they understand what they think that they understand. That's great. Since we don't have any more questions on Russo, we know what the rule of law is. We know what the standard is going to be. We know why the court did what the court did, and we're all good with that. Let's go to the quiz. While on duty, running a personal errand over lunch, military service person is involved in a car accident. Accident results in damage to a civilian vehicle. Service person admits, I caused the accident. I was distracted. I took a call. Will the civilian be able to recover from the military for the service person's action? Call of the question. Will the injured civilian be able to recover from the military because of the cause of action? No, because of the Westfall Act, No, because the service person was on Frolic. Yes, because the service person was on Detour. Yes, because of the ferries doctrine applies. Anybody want to guess which one it is? I'll take a hand. I'll take a hand. Oh,
So for this one, I had put they were on a Frolic.
why did you say it was a Frolic?
Because they were like running a personal errand while they were on break.
Right. Right.
So
Anybody else? Ms. Moore, other than Ms. Moore?
Do you mind going back to the question for me?
I said it was a detour.
Why was it a detour, Ms. Ross?
Because they were still on duty and they
Right.
were getting lunch.
Okay. Mr. Edwards, you good? Mr. Bernard, thoughts?
I don't know if I'm thinking too much about it just because of my past experience. But you don't really have lunch breaks. You have time that you're allowed to eat, but it's not really your time. You don't ever have your own time in the military.
Right.
It's just when they allow you to do things.
Right. Your time is the government's time, right? Right. I appreciate that, Mr. Bernard. I think I saw Ms. Jimenez, Ms. Hill, and Ms. Brown.
I agree with B, being a Frolic.
Okay. Frolic being a break. Okay. Ms. Hill.
Yes.
Ms. Hill.
I also said it was a Frolic because it was a lunch break, so that would be like considered a major detour.
Because it was on lunch. Okay. Ms. Brown.
Yeah, I was thinking the same thing. It tripped me up because I just remember you saying in class, anytime you see a lunch break, it's almost like a red herring. So that's probably what it was. But the question says that he was still on duty.
Right. Okay. This is one of the questions that I challenged Aspen on. I said, you guys have got to get better about writing these questions. The way you're writing these questions, in my personal opinion, is they're sloppy and they're not well written. The way Aspen explained it to me to justify the way that they wrote the question was, while on duty, that makes us think the way that Mr. Bernard's thinking, while on duty, but running a personal errand over lunch, which makes me think the way that Ms. Jimenez is thinking, the way Ms. Brown is thinking, the way Ms. Moore is thinking, the way Ms. Hill is thinking, makes me think that there is a break. What Aspen had to say is, the question says lunch. The question didn't say lunch break. So Aspen is of the mind that the on duty was supposed to signify that they were still on the government's time. I said, bollocks. It's a poorly written question. It's just a poorly written question, right? So what is the answer? According to Aspen, the answer is that the service person was on detour, not on Frolic, because Aspen said they didn't say lunch break, they just said lunch. I said, that's crazy. It's one of the ones that I complained about. There you go. I would never ask a question that was that sloppily written. But if you took the test, and Ms. Moore, I'm gonna need you to turn your camera off so that you can focus. I really appreciate you being present, but I want you to focus on the road. I know that you can hear us. I am recording this to my computer so that I can make a link, because some of the recordings that I've recorded to the cloud have gotten lost, but I'll make sure to post this. So that's what I think about question one. That would have been a situation based upon the analytics of the question. I would have thrown the question out because there's no way to answer that question accurately given the prompts in the call of the question. Ms. Asbury.
Good morning. I just had a question. Hopefully I'm not taking it too far, but I was just wondering, like on the bar, is there a possibility that we would encounter questions that might kind of trip us up like this? Because I had the same sentiments as my classmates.
Aspen does not write questions for the bar.
Okay, so we won't have.
I'm not saying what you won't have. I'm just saying in my experience of almost 30 years of looking at bar exam questions, I've never seen one so poorly written.
Okay, thank you.
That's all I can say. So that's question one. So if you took the quiz and you missed this one, don't sweat it. It was just a bad question, okay? Question two. Todd and Aaron are involved in a biking accident, which injures George. George sues both for negligence. The jury finds that Todd is 60% at fault. Aaron is 10% at fault. I'm sorry, guys, go ahead and read it. Let me let some people in. Okay. All right. Back to the question. Mr. Edwards, yes, sir.
So for that number one question, sorry, I should ask this before we move to the next one. So you could see a reasoning why someone would choose B, correct?
Yes.
Okay. That's all I need.
Okay, everybody good with number two? So who wants to jump in and give me an answer? We know that we've got three parties. We know that one is Todd, one is Aaron, one is George. We know that Todd has been determined to be 60%. We know that Aaron has been determined to be 10%. We know that George, who is also the plaintiff, has been determined to be 30%. That comes up to 100%. We know that his total damages, George, is $9,000. We know that we are in joint and several liability because it tells us that that's where we are. We know that Aaron is bankrupt. So what the call of the question, what the question has told us, if we just stay within what the question has said to us, this isn't requiring us to pull from anything that we've done. What the question provides for us is, in this jurisdiction, the bankrupt percentage is divided proportionately to the parties that remain. That includes the plaintiff. So the question is telling us everything we need to know. This isn't even requiring us to have attended not even one day of class. Ms. Giampo, I saw your hand. Do you want to give us an answer?
Well, now that you kind of explained it that way, I can see why my answer is wrong. I picked A because I was looking at it as if like a plaintiff filed for bankruptcy, then their percentages would be I guess like divided into other people. But I was looking at it as since the defendant is the one who filed bankruptcy, the rule didn't apply to him. So I just figured that George was still be able to recover what he was supposed to get, the 60% from Todd. But now that I see you're saying, like, if anyone files bankruptcy, the portion will even go to the plaintiff, is kind of different from what I was thinking in my head.
Okay. Well, and it's not what I've explained, it's what the question says, right? The question says the jurisdiction uses a modified joint and several liability rule, which provided that all parties, including plaintiffs, share the responsibility for bankrupt
plaintiffs.
That should be bankrupt defendants. Yeah. G2.
Yeah, that's why I was like, okay, it's
That's
only
not what I meant to do.
about
That's
the
not what I meant to do.
plaintiffs.
Yeah. So if you took the test says defendants. If you took the test, Q2, basically what they're saying is any of the parties, if any of them file bankruptcy, the portion that the bankruptcy party took now gets proportionately shared by everybody else.
Are you on the test? It says plaintiffs as well. It doesn't say defendants. It's the exact same question on Casebook Connect for the test.
Okay. So it still remains the same. Aaron filed bankruptcy. What happens?
He can't pay, right?
Right. I think that was Ms. Carpenter. Yeah, he can't pay. So what happens is what happens to his 10%?
Do they split the 10% between Todd and George?
Yes, Ms. Ross, they split the 10%. How do they split the 10%?
5 goes to George and 5 goes to Todd.
No. That would be an equal division. It has to be proportionate.
So
it has to be proportionate. Ms. Bari, yes?
I believe, well, because I also got it wrong. Even now, since I'm reading why. So based off what the original percentage was, that is what Aaron's portion is going to be divided by. So I didn't get that in the first read, but I get it now. So his 900, 60% is going to be having to be paid by Todd, and then 30% is going to have to be paid by George.
Right. There's explanation, right? Todd and George have to proportionately split what the bankrupt person has. Bankrupt person only had 10%. Todd and George have to split that proportionately. That doesn't mean 50-50, that's not proportionate. Proportionate is because Todd was 60%, Todd's gonna have to take 60% of it. And because George was 30%, Todd's gonna have to take 30% of it. Right? And so now George's percentage is gonna be 66.7%, or if you wanna do 66.6, however you wanna do the math, with that recurring 6, eventually going to a 7, right? And then the 33%, because that's 1/3 of the 10,000, you add those up and what do you get? You actually get that George is going to be responsible for $6,003 if you're doing the math to its greatest decimal potential. Yeah, but I don't have a $6,003 option. What's my closest option if I round down? $6,000. Right? What is that going to leave? That actually leaves Todd with $2,997. I don't have that as an option. If I round up, what do I get? $3,000. 6,000 plus 3,000 is $9,000. What's the clue? The clue is the bankrupt person's portion, whether he's the plaintiff or the defendant, the bankrupt person's portion becomes proportionately split amongst everybody else that's left. Not equally split, but proportionately split. That's why those percentages are so important. Number 3, take your time. This is not highlighted. For those, oh, Ms. Settle, give me just 1 second. For those of you who did not do the quiz, I highlighted these. So I'm thinking like if you're reading, the things that you might highlight as you read. It's not actually highlighted like this in the quiz. I just wanted you to know that that would have been, if I'm reading, those are the things that I would have highlighted. All right, Ms. Settle, yes.
I just had a question about number 2. So you take the amount that the bankrupt person was supposed to pay, and then like you would take 60% of that amount to see how much more the other, I can't remember the names, but like the other person was gonna have to pay.
Yes. Right, it's right here. George now carries an additional 2/3 of the 10%. Why does George carry 2/3 of the 10%? Because George is 2/3 responsible. How do I know that George is 2/3 responsible? Because it told me. Told me he was 60% responsible. Right? So I've got 10% to divide amongst 2 people. 10% to divide amongst 2 people. Right? So how do I divide it? It's a 2-to-1 ratio. It's a right. It's a literally 2-to-1. If George is 60% and Todd is 30%, that's literally a 2-to-1 ratio. What's a 2-to-1 ratio? That's a third. That's 66. That's 6 point, right? That's how he gets this additional 6.67%. I add that to he already had, I multiply that by the total damages. That's how I get that number. And I can do the same here, or if I'm just want to cut to it quickly, I'm going to take this number, subtract it from 9, and whatever's left is what Todd has to carry, right? Because Aaron's out of the picture completely. Okay. All right, we're here now. Nikki and Karen, both of them, Nikki and Karen are involved in an automobile accident. Andrew SEMA sues both for negligence. Jury finds Nikki 80% fault and Karen 20% fault. SEMA's total damages are $100,000. Traditional joint and several liability, what is the most that SEMA can recover from Karen? And Mr. Frank, what say you? Oh, I'm sorry. I'm so sorry. Mr. Bernard had his hand up. I'll come back to Mr. Frank. Mr. Bernard, yes.
I would say since it's traditional joint and several liability, they're all independently liable for the full extent. So it'd be C, $100,000.
$100,000. No bells, no whistles. That one's pretty straightforward. Questions on 3? No. All right, 4. Mr. Frank, this one's going to be yours. Hunters out, first day of duck hunting, very crowded. Hunter 1 is unlucky because Hunter 1 gets shot twice. First time that Hunter 1 gets shot, they get shot in the left arm by Hunter 2. Left arm by Hunter 2. Serious injuries, left arm, Hunter 2. Hunter 1 is then shot in the right leg by Hunter 3. Just a flesh wound, not that big. Left arm, significant. Right arm, okay. The 3 never met before. Assume that Hunter 2 and Hunter 3, that's the one left arm, right leg, were negligent. And Hunter 1 was not negligent at all. Hunter 2, that's the one that did the left arm that was significant in the injury. Hunter 2 left town and can't be found. So process can't be served. So they can't be sued, right? Hunter 1 sues the only remaining person, which is Hunter 3, who caused the minor injury to the right leg. What will Hunter 1, that's the plaintiff, that's the injured party, be able to recover from Hunter 3, who caused the minimum injury to the right leg? Mr. Frank.
Hunter 1 would just be able to recover for the leg injury, B, because the injuries are basically distinguishable because you are able to see that Hunter 3 caused the right leg and Hunter 2 caused the left arm injury.
Very nice. Injuries are divisible. Nicely done. Thank you, Mr. Frank. So even though the major stuff is happening here with this left arm, and And this is the one that's going to be the pain. And this is the one that's going to cause the most injury, right? Hunter 3 didn't have anything to do with this injury, right? These are divisible injuries. And if the injuries are divisible, I don't care what kind of jurisdiction I'm in, right? The injuries are divisible, then I'm only responsible for my proportion of the damage. Yeah, nice. Question 5. Fair and Jackie, auto accident, injures Barry. Jury finds Ferris 70%, Jackie's 30%. Right, that's all of it. Jackie is 30%, Ferris 70%, that's 100% of the damages. Shows that Barry suffered $100,000. Barry collects $40,000 from Jackie, which is actually $10,000 more than Jackie was supposed to pay. Jackie was only 30%. But Jackie, I don't know, had a big tax refund or something, I don't know. But Jackie paid an additional $10,000, paid $40,000. Jackie now sues Farah seeking contribution in a jurisdiction applying the traditional rules of joint and several liability. How much may Jackie recover? We had this one in class. Mr. Edwards.
I put $80 because Barry hasn't been made whole from the injuries caused by Farah and Jackie yet.
Here you go. 0, right? Because remember, and we talked about this when I actually pulled this one and actually used this one in class. Contribution is allowed in joint and several liability. Why? Because joint and several liability means that one can be responsible for paying for it all, right? We don't care. Our goal is to make the plaintiff whole. Well, that kind of sucks for the person who has to pay it all, right? Well, it's okay. Because the person who has to pay it all has some remedy. The person who pays it all can go after the other co-defendants, the other joint tortfeasors, to recover what they paid in excess, right? I can come back for contribution to get what I paid in excess, because I'm only supposed to be paying what's, I want to pay what I'm responsible for, but that can only be done after the plaintiff has been made whole. And in this scenario, it looks like the plaintiff is still down $60,000 based upon just a little bit of information the question gives me. They're down. So they haven't been made whole, which means that Jackie's lawsuit is not ripe. You may have used some of those terms already. It's not ripe. She sued too soon. She has to wait until the plaintiff is made whole. That's a good one. 6. Employee of a delivery service, delivering goods, injures somebody. Woman sues the company for negligent conduct. The company was not negligent in hiring or supervising, so pull that out, right? The woman can prove her actual damage are $125K. Her percent contribution, her contributory negligence was, well, not contributory, her comparative negligence was 20%. So what's left for the company to pay is $100,000, right? The company now sues the employee for $100,000. In a jurisdiction with traditional joint and several liability rules, what is the most likely amount the company will recover from the employee? Again, another poorly written question, but you should be able to answer it in spite of the poor writing of the question. Ms. Richard.
I said they would likely recover $100,000 because that is the plaintiff was made whole, so they can recover what they paid.
That's the answer. Nice. What's the problem with the question? The problem with the question is here. An employee delivery service while delivering, woman sues, company wasn't negligent in hiring, the company can prove actual damages, jury found her at fault, gave her an award of $100,000. There's a presumption that happens here that the writer of the question assumed that readers would assume that this award had been paid. Question doesn't actually say the award's been paid, right? Because what do we know about contribution and indemnification? Unless the plaintiff has been paid, unless the plaintiff has been made whole, you can't do either one of those things. And the writer of the question didn't say that the person had actually been, that the plaintiff had been made whole. So if you took the question the way that they wrote it seriously, your answer could have very easily been 0. Because your response would have been where there was nothing in the question that said that the person had been paid. That would have been a fair answer. It's a poorly written question. I would not write a question like that. And bar examiners have been in the business of giving bar exams for decades. They don't usually write bad questions. Right, but if you got 0, that's a fair answer based upon the way that they wrote the silly question, right? So if you got 0, I don't want you kicking yourself thinking, I don't understand, I don't understand, I don't understand. You do understand, okay? Another problem with this question is company sues now the employee for 100 in jurisdiction. What is this most likely, right? Oops, this whole most likely, either you're going to get the money or you're not going to get the money, right? Next one. What's my time? 10:46. Technician at a hospital. Horrible question, guys. It's a horribly. Why am I so reluctant to use connected quizzing? Why am I not taking the grades that you get from connected quizzing and putting part of that as part of your final grade? Because I'm tired of writing Aspen and telling them that their questions are poorly written. A couple of them on this one, they fixed. A technician at a hospital is a hospital employee. A patient comes to the hospital pregnant, complaining of early contractions. Emergency room doctor says, hey, technician, give that patient an ultrasound. Technician takes the patient alone into the ultrasound room, sexually assaults her. The patient sues the hospital based solely upon the technician's conduct. What is the result? The patient can recover from the hospital because of strict liability. The patient cannot recover from the hospital because of strict liability. The patient might be to recover from the hospital. The patient might not be able to recover from the hospital because the technician's now in jail. Of these horrible answers, none of which are on point with anything that we've learned, of the horrible answers, using the process of elimination, what is the best of the worst answer that you can have? Ms. Bass.
So this one I was a little confused about because I did put C, and the reason I put C is because when I think, or how I was taught, or what I believe to be right, when somebody is in the scope of their business or employment is doing what the employer instructs them to do, but if they go outside of, like what this particular technician did, he assaulted the lady. So that wasn't in his job description. So because of that, he wasn't liable. Does that make sense? Because that's how I thought about it in my head.
Because no negligent act is part of anybody's job description.
Okay.
No negligent act. If I take a quick detour, grab a cup of coffee while I'm out here making deliveries, and I bump into somebody in the drive-in, me bumping into them in the drive-in is not part of my job description.
Okay.
Right? So sexually assault is not part of the job description, you're right, but that's the injury, right? But if you put C, you put the right answer, right? And the reason you put the right answer is because all the other three are just ridiculous.
So if this were if it was different answer choices, how are we supposed to think about people?
They'd be liable. They'd be liable. I am a technician and I am a hospital employee, right? That's what it says. Technician at a hospital, I'm the employee. Patient comes to the hospital pregnant, complaining of early contractions. An emergency room doctor tells me, the technician, give this patient an ultrasound, right? So again, it's a poorly written question, but I'm assuming that I have the duty to do this or the expertise to do this, or it doesn't matter because my employer, some emergency room doctor pointed at me and told me to go do something. That's within the scope. Employer is directing me to do this thing, right? So I am following directions. There's no indication that I'm on a lunch break. There's no indication that I'm on a personal break. There's no indication, right? I am an employee working at the hospital. Doctor looks at me and says, give her an ultrasound. I go give them an ultrasound and I assault them. She sues the hospital. Question, at the time of the act, was I working within the scope or incidental to the scope of my duties? Absolutely. Absolutely. I was on the clock. I was told to do something by a managing or supervisor. I went to pretend that I was going to do that and I torted her. I committed a tort against her. I am absolutely within the scope of my responsibility. So that's one of the answers that you would have looked for, right? They try to do this red herring with strict liability. And you guys know, we're not talking about strict liability. We're not talking about strict liability. We don't care. We're not even going to entertain the question when we see strict liability. And we also know that the fact that the person's in jail has nothing to do with anything, right? Right. So the only answer left from those series of poor choices is C. Mr. Lindsay.
But does respondent superior still apply to intentional torts too? Because
that's a good
what
question.
I thought of it, it's
that's a good question,
or
right? Because we got a battery question in here that shouldn't even be in here because we're not talking about intentional torts. Good question.
I was just saying why I picked C is because it was not even a negligent act by the technician. It was something he intentionally tried to do. So that's why I picked C. Even though technically he was, I guess, in his scope of his employment, but he did something intentionally to harm someone else. So that's why I picked C.
I appreciate that. And Aspen couldn't respond that intelligently. Right? They don't know why they wrote that question the way that they wrote it, and they didn't fix it by the time we executed the quiz. Ms. Kilgore.
In the chat they had it was talking about to stay away from answers that are always or never, and then just what's your opinion on that? Someone just said they in the chat it was saying that someone picked C because they try and stay away from answers that are never or always. And so what would be your opinion on that? Is that something you say you should do? Or?
Yeah, well, I mean, I think that's true in practice. Lawyers never say never, and lawyers never say always. I always look for the 0.01% possibility. But again, as I talk to you guys about strict liability, respondeat superior is not a strict liability doctrine. It mirrors a strict liability doctrine in that it doesn't matter if the employer has rules or policies against the thing, but it is not a strict liability doctrine. And so I think this would be a time if I saw a strict liability potential answer to a respondeat superior question, I'd probably be okay with that's never the answer. That's as close as I'll get to never. It is 10:50. Class is over. For those of you who can stay, we can knock out these last couple of questions. If you cannot stay, I respect that. I'm recorded this to my computer, which will do a convert. So I know that I will be able to post this. It's not going to get lost in the cloud somewhere. So if you can stay for question 8, 9, and 10, stay. If you can't stay, respect that, because technically class is over. Okay. But for those of you who can stay with me, Mr. Edie, yes.
Since you say these questions are horrible, do you have like a recommended supplement or just a website or something where we can find some quality questions to practice?
I didn't say all the questions are horrible. Some of them are really good. The ones that are horrible are the 2 that I pointed out. So I try to run interference and do this in advance, but it takes them so long to fix questions. We run into the problem of us executing a connected quiz once we're technically done, right? So what do I think you guys should do? I think you should read the materials. What do I think you guys should do? I think you should go to Quimby. They have 1,000 questions. What do I think you guys should do? If you've signed up with a bar review course already, they have a zillion practice questions. So if practice questions is what you want, there's a ton of them out there. There's a ton of them out there. Other than the ones that I actually insert in the PowerPoints as we go through in class, right? Because I'm pulling them from somewhere. Well, maybe my brain, but I'm pulling them from somewhere. So if you want a good indication of what's going to be on the final exam, look at the questions that I've inserted in our PowerPoints that we actually spend class time working through together. It's a really good place to start. All right. Question 8. Pedestrian is walking across the street when she is struck by an automobile. Negligent driving. Left leg, right arm are severely injured. As she lay in the street awaiting for an ambulance, she is run over by a second driver. Left leg again, right? So first driver, left leg, right arm. Second driver, left leg again. Pedestrian sues both drivers as joint tortfeasors. Jurisdiction permits contribution between tortfeasors. The jury finds a special verdict which awards the pedestrian $100,000 compensatory damages for the injury to her leg. Remember, left leg, I had driver 1, I had driver 2, left leg, that's worth $100,000. As far as the right arm is concerned, she gets $20,000. Here's my options. Ooh. Oh, looks like I didn't give you the slide without the explanation. A, either driver can be required to pay $120,000. We know that not to be the case because the arm injury that's worth $20,000 is divisible, right? Right? That's not a joint and several. That's the second driver did that thing by itself, right? B, the second negligent driver can be required to pay no more than $100,000. Why do we know that? Because we know that the second driver contributed to a indivisible injury on that left leg. And we know that that indivisible injury on that left leg was $100,000, which means that the second driver who helped the injury on that left leg can be held responsible for no more than $100,000. That makes sense? I jumped the gun on that one. I left out the slide that was supposed to give you just the options before I gave you the answer and the explanation. But does that explanation make sense? Driver 1 got the arm and the leg. Driver 2 just got the leg, right? So driver 1 is only responsible for the $20,000 arm piece because driver 1 is the only driver that hit the arm, but driver 1 and driver 2 both hit the leg. And we don't know what damage driver 1 did to the leg. We don't know what damage driver 2 did to the leg. So the injury to the leg is indivisible, right? So that means I could get $100,000 from either 1 or 2. And if they feel that they've overpaid once I've been made whole, they can go after each other. All right, almost done. Question 9. This is a intentional tort. Mr. Lindsay.
I had a quick. So I got the answer right for the last one. Well, when she was waiting for the ambulance, can you say that it wasn't concurrent? You can say that subsequent. Can you argue that the subsequent?
Yeah, which helps the divisibility of the arm. But remember, was it Piner? Was it the Piner case where we were driving and we had subsequent hits, but we had only 1 injury?
Mm-hmm.
Remember? Right. And so we have subsequent hurts, but there's 1 injury to the leg, and that injury to the leg can't be divided. Does that make sense? Nice. Great processing, Mr. Lindsay. I appreciate your analysis. This one is about a intentional tort, which is not what we're doing. Delivery truck driver is tired, middle of his shift from all of his driving, middle of his shift, tired of driving. So he stops by a coffee shop to get a latte. While in the shop, the truck driver, in a hurry, not acting carefully, accidentally spills hot coffee on another customer in the store, causing serious burns. If the other customer sues the employer of the truck driver for her injuries arising out of the spilled coffee, what do you propose is going to happen? That she may recover? If the trucking company was negligent in hiring, we know we haven't talked about that. That's not an issue. That's likely not the answer. She may recover only if the truck driver was negligent while acting in the course and the scope of employment. Just to hear those words makes me sound good, right? She may not recover because the truck driver, not the trucking company, injured her. Well, we know that's not right. We know respondeat superior. She may not recover if the truck driver was negligent. Well, we know that's not right because we know respondeat superior. So what must the answer be? Right, that is a really simple, straightforward respondeat superior. Delivery driver, middle of the shift, makes a quick stop, doesn't say anything about a break. I get my latte, it's too hot, don't realize it, but I spill it on somebody, they burn, they go after my employer. If at the time of the negligent conduct, I was working within the scope, right? This sounds like a detour to me, right? I wasn't on a scheduled break. I wasn't on a lunch break. I'm gonna make a quick stop. That sounds like a detour. If I'm on a detour, I know that according to the doctrine of respondeat superior, my employer can still be held liable, and that's all of them. So 7 of them are great questions. 7 of the 10 are great questions. 1 of them had to do with an intentional tort, didn't belong in this group of questions. And the 2 of the ones that were poorly worded were just poorly worded. But if you took it, the 2 that were poorly worded, if you got those wrong, according to what Aspen says, again, don't beat yourself up about that. Because the way that they were written, more than one answer was a plausible answer, right? And then the other 7 were great, and we didn't address intentional torts because you addressed intentional torts last semester. You're not going to be touched with intentional torts on anything that I do for the final this semester, and you would have gone through a bar preparation before you go prepare for the bar where you ever see intentional torts again. And that's today. Yep. Yay, fantastic. What are we gonna do on Monday? We're gonna brief the case that's set for Monday. Questions? I appreciate you guys working so hard. Good night. Good night. Goodbye, Bernard. I appreciate you guys working so diligently and so hard, because by doing that and really wrestling with Russo, that actually saved us a lot of time from having to go through Russo. And we were able then to jump in to this review of the damages. So keep working hard, keep struggling, keep fighting, keep getting frustrated, keep up to your elbows in it. I promise you it's gonna pay off. Ms. Brown and then Ms. Carpenter.
I'm not sure whether or not you said that responded superior applies to intentional torts.
I didn't answer that question at all, because I'm assuming you covered that in intentional torts. We're not covering intentional torts here.
So we don't have to worry about it. We don't have to worry about that being on the exam, whether or not it's an intentional tort dealing with respondent superior.
You're right. I'm not going to give you any intentional tort.
Okay,
You're
great.
absolutely. So kind of going back to never, never, ever, ever. Yeah, I'm not going to give you an intentional tort on my final. Y'all were beat up about that. Y'all were tested on that. Y'all went through that process already.
Okay, great. Thank you.
Yeah, absolutely. Thank you for the clarification. Ms. Carpenter, I saw you shake your head. Was that your question as well?
Yeah, I had that was.
No intentional torts. No intentional torts. I'm not touching it. And by the time you get ready for the bar exam to go over it again, you would have gone through a bar prep class and they will have you up and ready to go. But we're not touching intentional torts. That's why I didn't even do question number 9. We're not touching them. Okay. All right. Ms. Ross, were you chatting with us? No. Okay. Ms. Asbury, you feeling good? Ms. Asbury, you good?
Oh, yes, I'm sorry. I wasn't raising my hand. I was scratching my forehead. I'm sorry. Thank you.
Ms. Isaac, I saw your happy, lovely, smiling face. Were you going to jump in? I guess Ms. Isaac hung up. All right, guys, that's all I've got. So I'm going to go ahead and end it for everybody. I'm going to let this convert on my computer. I'm going to go ahead and hang out at my desk for the next 10, 15 minutes that it takes to convert, so I can go ahead and post it immediately. So if this is fresh on your mind, you will be able to get access to it quickly. So,
Professor, I'm sorry.
No, go ahead. Ms. Carpenter, please.
Yeah, I know that me and my study partner had wanted to meet with you today regarding the quiz. So I think that I just want to let you know, I think we're good as far as that, but I probably will be reaching out again to go over the duty and the negligence hypo as well, but I'll probably reach out over the weekend.
Okay, and I remember you asked me about Saturday. I'm obligated Saturday, but if you and your study partner want to chat or do a Zoom or do a whatever, I'm open Sunday.
Sunday, okay, I'll reach out. I'll talk to her because we're heading to the library right now, but I'll talk to her and then I'll reach back out to you.
The only thing I'm doing Sunday is working out, and I usually do that at 3 or 4 in the morning if I can.
Okay.
So late morning, Sunday afternoon is a great time. If you guys want to reach out, I'll pop onto your Zoom or however you want to do it.
Okay, sounds good. Thank you.
Okay, you're welcome. Absolutely. Ms. McClary, you have been smiling, and I didn't even get to hear your voice this morning. What is going on with you? Oh, honey, you look marvelous. Ms. McClary's like, well, hold on a second.
Thank you. Nothing.
You good?
Yes, ma'am, I am.
Because usually I look to you and Ms. Kilgore to usually keep the conversations going. And the last couple of class sessions, you've been kind of quiet on me. I want to touch base with you.
Okay.
Everything is good?
Yes, ma'am.
Okay. All right.
Thank you.
As you guys get into it, if you find that it's not good, reach out to me. Even though I'm committed on Saturday, that doesn't mean I won't respond to a text. That doesn't mean I won't respond to an email. I just can't jump on a Zoom, but if you're studying this stuff tomorrow and need something, reach out to me. Okay?
Thank you.
You're very welcome. You're very welcome. Ms. Dirtez, you have been kind of quiet as well. Are you good?
Yes, ma'am. I'm doing well.
Okay. All right.
I will be reaching out to you though to just get some clarity on some things. So I'll send you a text.
Send me a text. I can't jump on a Zoom tomorrow, but I'm all yours Sunday.
No problem. I'll definitely do that. Thank you so much.
All right, very good. Fajardo, Bryce, Morgan, you guys good?
Yes, I'm good. I just wanted to ask what case we were supposed to brief. I apologize for asking.
Don't apologize. Let me see if I can get to it quickly because I've got all my screens, dedicated right now, and I can tell you, and no need to apologize. Ms. Fajardo, let's see. We are now, oh my Lord, we have covered some territory. We are now going to get into owners and occupiers of land, Ms. Fajardo, and that's going to be the Hill versus National Guard in chapter 10.
Awesome. Thank you so much, Professor.
Of
Sorry
course,
about that.
of course. And if you need anything as you're studying, just let me know. I know everybody's starting to look toward the final. So if you need some things clarified, sweep off some cobwebs, get some clarity, that's what I'm here for.
Thank you, Professor. Have a great weekend.
You too. Bryce, Morgan, y'all good?
Yeah, I was just gonna ask you when you're available, but you kind of already answered that question when you said on Sunday, because I was gonna try to do like a writing sample and let you see it to see like
beautiful.
you would be looking for the final. I've been trying to like make flashcards for like the different subjects just to make sure that I understand and get it under my fingertips of what you're looking for. So when I do that, like when I finish that and then put it to writing, I just wanted you to check it. And also I want to apologize for coming in late. I had an interview. It was rescheduled for today. So I was like, oh, should I go to class? So I was like, let me just try it. So
Number one, yes,
sorry.
come to class. And I thank you. Number two, I saw your text message and I appreciate you letting me know. And number three, how did the interview go?
I think it went really well. I'm excited. So hopefully I'll be able to hear from them. She said that she will reach back out midweek next week.
Okay.
It's for Mitsubishi. So hopefully I get that because I really wanted to do like something remote because I think I also want to do summer classes. So I don't know. We'll see. It's in God's hands. I don't know. So.
All right, Miss Morgan, do your thing. Let us know how you do.
Thank you. I appreciate it. And I'll send you something over pretty soon. I just want to make sure that it's like right before I present it with you and let my big L look over it before I let you see it.
I love it, right? That's what all of this time is for, right? I want to use it. And I think that's a great way to use it.
Okay, perfect. Thank you so much. Enjoy your weekend. I'll talk to you soon.
Yes, absolutely. Bryce, you doing good? Bryce? Going once, Bryce, going twice, Bryce. All right, have a great weekend. See you soon.